Good afternoon, everybody. My name is Chris Justice. I am an employment lawyer with Samfiru Tumarkin. Some of you may have seen me before. I've done this Q&A a number of times, and so I'm back again today. Happy New Year as well to everyone, if you haven't seen any shows of ours recently. But this is where we try to answer as many questions as possible regarding employment law related type stuff. So if you have questions regarding maybe something about a job you're considering on getting into, maybe you have questions on a job that you're currently in right now and maybe having some issues, or maybe have some questions about what's going on in the workplace, or if you have any questions on your way out or after having been let go. So whatever it is, if you've got your questions, please get them in today, and I'll do my best as always to answer as many as possible. Usually what I do at the beginning of these types of shows is talk about a few things that have currently been going on in the news, as well as to maybe speak on some more general issues regarding employment law itself. So today I was going to focus first on the fact that there are a lot of companies, especially in the tech sector, that are and have been instituting a lot of layoffs and terminations. So one would be Amazon. There's continuing layoffs with respect to that company. There's been announcements of another 18,000 employees getting laid off. You've got other companies like Salesforce that are looking to trim about 10% of their workforce this year, claiming that they're apparently overhired, or that they did overhire in the past. So a lot of people, as I say, either losing their jobs right now or set to lose their jobs. And so I thought it'd be a good opportunity to sort of just refresh what oftentimes I talk about, which is your rights upon termination, and specifically your rights to severance upon termination. So if you're an employee and you've lost your job and you're wondering, first of all, how much severance am I owed? There are going to be a number of factors, or at least a few key main factors, that are going to determine or influence potentially how much severance you can get or should get. The first thing I always do is to look at the contract. So if you're somebody who has lost their job, but before you did, you had signed a contract, maybe when you were hired, or maybe at some point afterwards, that's one of the first points or parts that I look at, because in your contract, if you've signed one, there may be a termination clause, and it may speak to what the company is going to give you in the event of a termination. And a lot of times these clauses are designed to limit your rights to just the bare minimums, and not give you the potential to getting your potential maximums, which would be in some cases upwards of 2 years of full severance. So that's why it's very important to look at the contract that someone signed to figure out whether and to what extent there is a section or some language in the contract that might limit your rights. So that's one starting point. But if there is no issue with respect to your contract, then the courts typically look at 3 or 4 factors when deciding how much severance you should potentially get. The first is going to be your age at the time that you were let go. So if you're in your, say, mid-50s or older, courts will typically give more severance for individuals let go in that sort of age bracket, or upwards of that amount of years. Your length of service is another factor. So again, longer service typically is going to allow you to have the potential of getting more severance. However, what I always say when it comes to how long somebody's been at a company for, a lot of people who have only been at a company for maybe 6 months or a year or 2 years may actually think that they're going to be entitled to very little. But when it comes to someone's length of service, for those who have shorter term duration or shorter number of years of service, they can get disproportionately larger packages than someone, say, with a larger amount of years of service. So don't think that because you have very little service or very little years in with a company that you're owed essentially nothing. That's not true. There are a lot of cases where people who have been somewhere for very little time have gotten 2, 3, 4, 5, 6, 7, 8 months of severance. But length of service is another factor for sure. The position that you held or that you had at the time you were terminated is going to be the third of the main three factors. So naturally, if you're somebody with, say, a role as a CEO or an executive VP, or someone who's maybe at a director level or in that area, you're typically going to see your entitlement to a package or severance package being larger than if, say, someone's working at a job for minimum wage and there's a lot more opportunities out there available. Because the availability of new work and sort of how long it should take someone in your position to find a new job after you lose one is also going to be considered or factored in when sort of figuring out what your severance entitlements are. But as I said before, you could get upwards of 2 years of severance. So definitely makes sense if you're someone who's lost their job, again, whether it's part of these layoffs, trimming of the workforce, whatever the case may be, to get in touch with us and give us a call, because whatever severance package you're going to be offered or have been offered, in all likelihood is going to be much, much less than what your actual entitlement is. So give us a call. You'll definitely want to do that. Do not sign a severance offer once you get it. Your company is going to ask that you sign something before they offer you the full value of the severance package, but don't sign it. Get it reviewed by a lawyer first. And as I say, in almost all cases, you're going to look at much, much more money than what's being offered. Having said that, I'll get back to some few talking points I have, but I do want to get into a couple of questions that I have from the audience. So the first one comes from Tasso on YouTube. And Tasso is saying that their LTD, long-term disability, expires in February of this year when they turn 65, which is very common. In most, if not all, disability policies, you're going to have a certain cutoff when it comes to the age, regardless of whether or not you are or still or are not disabled under the policy's definition. But provided you meet that definition of disability in whatever policy you have, in theory, you should be entitled to long-term disability benefits. So again, TASOs are expiring in February. TASO's been on long-term disability for 3 years, and there is a plan to go back to work. And they're asking if their employer can refuse employment. So in other words, refuse the request to go back to work. So, and this is a good question. So thank you for bringing that in. This affects, I'm sure, a lot of people. A lot of people who sustain some kind of an injury, they go off on a medical leave of absence, and sometimes they apply for short-term disability, sometimes long-term disability, and sometimes those disability policies are actually offered through the company. And so when somebody is off on a disability leave, an approved disability leave, the employer is obligated, generally speaking, to accommodate that employee. So Tasso, in your case, I don't know exactly what's happened as of now, but I would imagine, or I'm guessing, that your employer is aware of the fact that you've been off on a disability leave, that your employer is aware of the fact that you have an interest to go back to work, because these things should typically be communicated. Anytime anyone's off on a disability leave, you want to give, if there are updates to your condition, you want to give those updates to your employer. Certainly not on a weekly or even necessarily a monthly basis, but when there's a change in your condition, you want to give them updates. And then when there's an intention to go back to work, you'll want to sort of try to plan that with your employer as best you can to sort of set a date to return. So assuming that's all been done and you've got a date sort of selected to go back to work, or an idea of when you will return to work, then your employer should, generally speaking, be able to accommodate you and have you come back. You are, again, when you're on a leave of this nature, going to be entitled to some job protection. So if you're working in a specific role, the idea is that when you do return, that you're given either that role or a very, very similar role to that upon your return. If your employer refuses to have you go back to work, maybe they tell you that they no longer have a role that's available for you, or that they only have a different role available that's very different from what you were doing before the leave, then that could be an issue. I guess technically an employer could refuse to recall somebody back, but in most circumstances, that's going to automatically start off looking very bad from the employer's perspective because they have a duty to accommodate generally. And so a lot of times I see employers just simply not have someone come back because it would be an inconvenience to them more than anything. Maybe they hired somebody to replace you while you've been off, but then when you come back, they think, no, we actually prefer this other person, and they no longer want you in that job. And that's a huge issue for companies. Not only are they going to be seen as having essentially terminated your employment, but they could also very easily be seen as having discriminated against you on the basis of your disability. In other words, if it weren't for the fact that you went on a disability leave, this likely or may not have happened whatsoever. So there would be a lot of issue, I think, or there would be a lot of issues that the employer would have when they generally refuse to have someone come back after a disability leave, especially if there's been a date that's planned, there's a certain expectation, and they just don't want to accommodate that employee. So Tasso, if you're in a situation like that where your employer refuses to have you return back to the position you had, or again, very, very similar, with all the same terms that were in place before you left, then that could very likely be a breach of contract, a breach of your human rights. And depending on how long you've been with the company, because we know you're about to turn 65, so your age is going to be a situation where you could get more severance. So depending on how long you've been with that company, what your role is, your entitlements could be very significant. And again, not just from a severance perspective, but also potentially a human rights sort of bad faith type perspective. So these situations can be a bit complicated as well. And you want to make sure that you're not sending any wrong signals or messages. So you want to get in touch with us, I think, Tasso, just to schedule a consultation at the very least. And so we can kind of go through what's been happening and sort of set you up in the best way so that your rights or the potential rights you have are as great as possible, and that you have as many options open to you as possible. But thanks again for getting a question in. I think it does affect a lot of people, just generally those who are off on a disability leave or a medical leave of some sort. And that was going to be actually one of my other talking points, is sort of what to do in situations where someone's off on a disability leave, what to expect, and what may happen upon a return or not a return. So again, Tasso, thanks for the question. But moving on, I've got another question from Sarah through Facebook. Sarah's asking or saying that they're working from home, or that they have been working from home long before the pandemic started in 2020. And as the new year has begun, so in other words, now we're into 2023, her boss, Sarah's boss, is requesting that Sarah come into the office more often. And Sarah's asking if she can refuse this, and what happens if Sarah loses her job as a result of refusing to come in more often. So it's a good question, Sarah. And again, for anyone who's been working from home, especially those who are working from home before the pandemic, and are now being asked to go into the physical office, you'll want to contact us as well before you have that kind of a discussion with your employer, so that you're not outright refusing something that your employer may have the ability to demand or require of you. Now, in Sarah's particular situation, it could very well be the case that, as she said, before the pandemic, she was working from home, and that it was an expectation of hers that she just continue to work from home. She may have an actual deal in place or an agreement in place with her employer, like even through a written contract that says she is to work from home. And so that may be a very solid term of her employment, that she work from home and not actually go into the physical workplace. And so if an employer or your boss is asking you to come into the workplace, and it's always been the case that you've been working from home even before the pandemic, then it would be reasonable to say that you expect to continue to work from home. And by your boss or your employer asking you to go into the workplace, if that's not something you want to do, and assuming it's a pretty big change to the terms of your employment, I think you could reasonably say no to that because, again, you had signed up under the condition that you'd work from home. Now, there are other scenarios where someone may have been working in the office before the pandemic and only started working in the office after the pandemic started. And they may think that they have an inherent right to continue to work from home because the pandemic has proven that they're capable of doing that. That's a little bit of a different situation potentially than the one Sarah's in. Don't automatically assume that because you've been working from home for the last year or two, that you can just continue working from home indefinitely. I think, again, it goes to the question of whether or not you working from home on a, say, a permanent basis, if that is a term of your employment, then you would generally have more right and more power to say, no, I don't want to go into the office. Again, assuming there might be a lengthy commute or something associated with doing that. But if that's not a term of your employment and it's just something that's sort of developed recently, there are a lot of situations where your employer can ask you to come back into the office. And if you say no, you may be seen as having quit your job. And that's why I was saying earlier that it makes sense to contact us before, like early on in these situations, because you don't want to be saying no to something and then find out that you actually, can't say that unless you want to risk being considered to have quit your job. In Sarah's situation, if there was already a right to work from home that was established before the pandemic and she refuses to go into the office and loses her job, Sarah's going to have a much easier time of getting her full severance entitlements as a result of losing her job. So again, if your company, if your boss breaches your employment by requiring you to go into work when it was never the case before, that in the eyes of the law is considered a termination. And so Sarah could, as I said, potentially be owed whatever her full severance rights are for them sort of insisting she come in and therefore breaching her employment. So it kind of depends on each situation, but someone may or may not have the right to refuse a request like that. And as a result of that, they may or may not be entitled to their severance. But thanks as well, Sarah, for your question. I've got another question in from Kareem on YouTube. Kareem is asking whether or not somebody can be expected to come to work early and then work unpaid. Kareem was apparently told that this is part of the workplace policy, but Kareem believes this is unreasonable. So this supposed workplace policy that requires you to come to work early and work unpaid. Well, first of all, one question would be whether or not Kareem's contract, say if Kareem did sign a contract of some sort, sets out the hours of work and the basis on which Kareem would get paid for working those hours. It could be an hour by the hour sort of rate. It could be a salaried position. But I think it comes down to what the expectations are as far as Kareem and the company are concerned. So if you've got a contract that says, for example, you're to work 9 to 5 and you're being paid, a salary of $50,000 or an hourly rate of whatever, for your employer to say, well, we actually want you to work at 8 o'clock in the morning, not 9, and that first hour is going to be unpaid. First of all, that would raise some alarm bells, and I certainly would want to talk to a lawyer before communicating further with my employer, or at least tell my employer that I needed to kind of review the situation, review this workplace policy, because I think one thing Kareem needs to know, and others for that matter, is that just because there's a workplace policy or some sort of policy that the company has, and even if the company's policy says whatever it says, don't assume that you have to therefore abide by that policy, especially a policy that you haven't reviewed before, that you haven't signed off on before. A lot of times I find that companies will have you sign a contract, but then later on refer to other things that are not in that contract, but that are in different booklets or policies that, again, you may not have reviewed or signed off on. And a lot of people may assume that they therefore have to follow that policy. and then they end up following the policy, and that then becomes a term of their employment. So I think, some of these questions would have to be asked first before I could tell Kareem exactly how to proceed. But this may be a situation where Kareem can say no to the request to work early if it's outside of what the expectations were, even if it's in a policy, and Kareem may then be entitled to some severance. Whereas if there's a policy that says you have to work earlier, then you may not have as many options. But I think it looks like Kareem's probably got at least a couple options, and that being to either accept this supposed policy or push back and say that wasn't a part of the terms of Kareem's employment. And from there, the company may decide to let Kareem go, in which case she'd likely be owed severance, versus that person being seen as having quit. But thanks as well for your question, Kareem. I've got another question in from JX2 on YouTube. And JX is saying, if you get a new job and they keep giving you shifts, even though you haven't signed the contract they gave you, are you working without a contract? Can they dismiss you if you don't sign? And Jay's in BC. So, okay, so just so I'm clear, Jay's got a new job. They're giving Jay a bunch of shifts, but he hasn't yet signed the contract they gave him. So that may or may not matter, first of all, Jay, but it's good to sign a contract because it will specifically set out what the expectations are, presumably. So I would say it's always good to have a contract. Now, if you sign a contract a month or 2 or 3 after you've already started working in that role, and the company tries to rely on that contract later, they may or they very likely won't be able to use the contract, which could benefit you. So Jay, there's a somewhat common situation that happens where, say someone gets a job, they work 9 to 5, they get paid $50,000 a year, and they've been working in that role for a month, and then the company has them sign a contract regarding this role like a month or 2 later, after they've already been doing what they've been doing, getting paid what they've been getting paid. And then so the question becomes, what benefit am I really getting now out of signing this contract? I've already got the job. I'm getting paid. I'm working this number of hours. I'm giving you guys, my time and services. So by this point, what good does it do me to even sign a contract? It probably doesn't do you a whole lot of good, because a lot of times these contracts have language in them that try to limit your rights in some way. However, the problem for the company is that because you're not getting any benefit at the time you sign this contract, because you've been working for the last month or 2, the company will likely not be able to rely on that contract. So if they try to have you sign a contract a month or 2 after you start the job, and then later on let you go, let's say, or terminate your employment and try to rely on a termination clause, I think it's going to be a lot harder for them to do that. What they should have done is have you sign the contract before you work. That's what any employer should generally do, is get an employee, hire an employee, get an employee to sign that contract before they start working, before they start getting paid and doing their job. A lot of times companies are a bit lazy when it comes to getting their contracts signed on time. And that, as I said, in a lot of cases is going to be beneficial for the employee. Jay, they can, however, dismiss you. That, just because someone doesn't have a written contract, you can still be dismissed essentially at any time. But your employer, if they do that, is going to have to likely provide you with your full severance. And they're not going to be able to rely on a contract that, again, they had you sign a month or 2 after you started working. So you want to, I think, get in touch with us, Jay, just because there's a few issues going on. And I would say that before they have you sign the contract, generally, you're going to want to get some legal advice. And I also think you should be made aware of what, if any, red flags or anything like that are in the contract. Even though they made the contract or parts of the contract may not affect you, I think it's still beneficial to know sort of what the potential is. But as I say, it could work out in your favor if they dismiss you, but they do still have that general right to do so, as long as it's not in bad faith or discrimination. So I know you're in BC, Jay, but give our BC offices a call, and I'm sure they can set up a time for a consult and take it from there. But thanks for your question. I've got another comment in from a LinkedIn user who was hired by a firm as a full-time employee. There was a probationary period clause. They were going to reimburse this person for professional fees, but a week before the probation period ended, the 3 months, they were asked to sign an extension of a probationary period, and they're asking if it's legal. So yes, it is legal for an employer to, I guess, technically extend a probationary period. However, an employer will not be able to essentially dismiss you or terminate you from your employment after 3 months without paying you severance. So usually the probationary period is a time where an employer can sort of decide whether they're a good fit with the company. And if they aren't, then depending on how the probationary period clause is designed, the employer can let that person go without any payment or notice whatsoever. A lot of times employers think that they can extend the probationary period and then still let that person go without providing them with any severance. And that's where they're incorrect. So they can technically call, maybe months 4, 5, and 6 with you, a continued probationary period. But as I say, they won't be able to escape their obligations, I should say, as far as severance is concerned, if they do let you go. And as far as them saying that they're going to reimburse you for professional fees that you paid for, that may simply be something they have to do. It seems like you guys had agreed on your fees being paid for, regardless of whether you pass or don't pass the probationary period. Unless there's something in your contract that says you have to pass the probationary period in order to get your fees paid for. And in that case, maybe they can hold off paying the fees, but there also should be something in your contract that says they can extend the probationary period as well. So if there isn't a section of the contract that allows them to extend the probationary period, and they're saying to you in the contract they would only pay your fees if you pass the probationary period, then I think you could actually get your fees paid for as long as you pass the first 3 months, even if they have you on a probationary period still. So hopefully that answers your question. But I think that if they are trying to potentially avoid paying you your fees, that could definitely be an issue. Again, depending on what your contract says or what the contract would entitle them to do. And otherwise, you'll have to just wait to see if they terminate or not and what you'd be owed at that time. As you can see below, though, 1:00 p.m. Eastern, Wednesday. So this January 11th, Lior Samfiru himself will be doing a Q&A. So that's my time for today, but definitely join us again on that day with Lior. Come with all your questions relating to employment law, all things employment law. And as always, he'd be happy to answer as best he can. But thanks again for joining me today. Again, Happy New Year to everyone. And I will see you all soon enough. But until then, do take care. Bye for now.